Hello and welcome. My name is Nasser Hafizi and I am a solicitor by profession. I also bake cakes. In this 20-minute or so presentation, I'm going to outline the Counter-Terrorism and Border Security Bill 2018, herein referred to as the CTBS Bill. The CTBS Bill has been described as a much-needed digital fix, while one commentator, a Member of Parliament, described it as, in quotes, "This cat-handed bill would criminalise curiosity, academic research and journalistic investigations," close quotes. Whatever our view of the CTBS bill and its proposals, it certainly makes some very important changes to terrorism laws, and if passed into law, it's likely to affect many people and sectors, including journalists and online commentators and messengers, human rights and charity workers present in conflict zones, members of particular faiths and nationalistic groups in Britain and Northern Ireland, campaigners for political change here and abroad, and academics, students and just the plain curious. I've separated this presentation into three main parts. In the first part, I'm going to explain briefly why the government is seeking to pass the CTBS bill through Parliament and why in particular they say these new proposed laws are needed to counter terrorism. In the second part, I'm going to take you through some of the main clauses in the CTBS bill and explain some of the concerns and observations expressed by others about the particular clauses in the bill. And finally, I want to give some general advice to those who would like to comment on the CTBS bill, how they may wish to express their concerns or support or even put forward their own recommendations to those in authority about how to keep this country safe whilst protecting liberty. Please remember that during this presentation, any opinions are mine alone. Please read the CTBS bill yourself and always seek specialist legal advice if you are affected as a victim of crime or you are affected by the counter-terrorism laws where there is a suspect or a defendant. Let me now turn to the first part. Why is the government seeking to pass the CTBS bill through Parliament, and why in particular they say these new proposed laws are needed and will help counter terrorism? In the government's overarching fact sheet 2018, the following important background points are made. In quotes, in 2017, the UK was subject to 5 terrorist attacks in London and Manchester, which killed 36 innocent victims and injured many more. Since the Westminster attack in March 2017, the police and security services have thwarted 12 Islamist terror plots. Over the same period, the police have been able to prevent a further 4 extreme right-wing inspired plots, close quotes. The government's overarching fact sheet continues, in quotes, the provisions in the bill will underpin our approach, ensuring the police and prosecutors are able to have the powers they need to enable intervention at an earlier stage in investigations, leading to more prosecutions for terrorism offences, backed by longer prison sentences and stronger management of terrorist offenders after their release. So, close quote. So, when the bill was published on the 6th of June 2018, the government said it would, in quotes, update and close gaps in the existing counter-terrorism legislation to ensure it is fit for the digital age and reflects contemporary patterns of radicalisation, close quotes. However, some have argued that there are no major gaps in terrorism. According to the respected Independent Review of Terrorism Legislation, Maxil QC, who has advised on more than one occasion, in quotes, we have sufficient offences and do not need any more, close quotes. And again, Professor Clive Walker, one of the leading, if not the leading expert in terrorism legislation, said this, in quotes, the failure to identify major gaps is further emphasised by the findings of the 3 weighty reports, none of which called for major legal changes, close quotes. Well, the government says more laws are needed to counter terrorism. Before I explain some of the clauses, another criticism, apart from the lack of need and urgency, is the lack of debate and public consultation, especially with the late introduction of the proposed terror offence known as the designated area offence in September 2018, a clause I will explain shortly. Let me now turn to some of the clauses in the CTS Bill. I'm going to mention the following 4 proposed changes to counter-terrorism in a little detail. 1. The expressions of support for prescribed organisations offence. 2. The publication of images offence. 3. The one-click offence. 4. The designated area offence. Other clauses I will explain briefly include extraterritorial jurisdiction on a number of offences, including glorifying terrorism, barring the admissibility of evidence in criminal trial, oral admissions made in an examination at a port under Schedule 7, hostile activity power, similar to the Schedule 7 power, to stop passengers, and allowing local authorities to refer individuals to the channel panels for de-radicalisation. So, let's look at the first clause, expressions of support for a prescribed organisation. The government wants to extend the existing offence of inviting support for a prescribed organisation, Schedule 12, Section 12 of the Terrorism Act 2000, in a significant way to cover expressions of support, that is, opinion and beliefs, which are reckless as to whether they will encourage others to support the organisation. Now, a prescribed organisation is one which is banned in this country. There are currently about 88 groups which are banned in the UK. The most recent were the National Action and also known as Scottish Dawn. What are the main observations and criticisms of this proposed law, expressions of support for a prescribed organisation? Let me try to explain. With the expressions of support offence, it is no longer necessary to prove a person must, in quotes, knowingly invite support, close quotes, for a prescribed organisation, but simply be reckless as to whether they will encourage support for a prescribed group. This means that a person who shares the same or similar political ambitions as a prescribed group can commit a terror offence through reckless comments made in public. In his written submissions about the CTBS Bill, Professor Clive Walker provides examples. He says, in quotes, "Thus, I might say that I support the political objectives of the IRA in the sense that I agree with their aspirations for a united Ireland. Of course, I might qualify that statement with a rejection of their violent means, which they say they renounced some time ago. But that qualification does not afford a defence, since I am still supporting an organisation which is prescribed," close quotes. Similarly, a person may commit the expressions of support offence if they express a general desire for a united Middle East where the Sharia, Islamic law, rules supreme, as this may be similar to the political ambitions of a prescribed group. There may be no defence for such a person who rejects specific violence in the pursuit of those objectives, as they may be made recklessly and taken to encourage support for a prescribed group. Could a person be at risk of this offence if they recklessly make comments about Irish nationalism, or Scottish independence, or a religious society, or white supremacism, or anti-immigration, or showing solidarity with the oppressed and the dispossessed, or being against particular regimes because such comments are shared with a prescribed organisation? Well, this offence will certainly make it easier to prosecute individuals who share opinions and beliefs with prescribed organisations. Liberty, the human rights group, have major concerns that this offence, by removing the requirement of intention, that is, the intention to specifically support for a prescribed organisation, in quotes, this bill removes the requirement of intention. In doing so, it pushes the law even further away from actual terrorism into the realm of pure speech and opinion. Close quotes. It is not surprising that some suggest that without an actual encouragement to acts of terrorism, this offence is akin to, in quotes, a thought crime, close quotes. An observation made by Professor Clive Walker when he says, in the absence of that emphasis on an outward-facing action, the offence might be criticised as a thought crime, close quotes. The second proposed changes to counter-terrorism laws contained in the CTBS Bill is the publication of images offence. Again, this proposed new offence, while supported by many parliamentarians, has a number of significant critics too. The proposed clause creates a new offence criminalising the publication by a person, whether a still or moving image of an item of clothing or an article in such a way or in such circumstances to arouse reasonable suspicion that the person is a member or supporter of a prescribed organisation. The proposed new offence would cover photographs taken in private and later published, which, according to the explanatory notes of the CTBS Bill, may not be covered by existing counter-terrorism legislation, namely Section 13 of the Terrorism Act 2000. The example given in the explanatory notes is, in quotes, a person uploading to social media a photograph of himself or herself taken in his bedroom, which includes the background of an ISIS flag, close quotes. Concerns and observations surrounding this offence have been expressed. 4 are mentioned here. 1. The offending behaviour is already covered by a host of terrorism and public order offences, a point made by the Joint Committee on Human Rights. 2. As Liberty states, in quotes, further criminalisation of photographs of costumes only exacerbates the risk that law enforcement officials attempting to interpret the meaning of a photograph will mistake reference to endorsement, irony, for sincerity and childish misdirection for genuine threat. 3. The UN Special Rapporteur on Human Rights expresses criticism of the publication of images offence in this way by suggesting that, in quotes, it runs the risk of criminalising a broad range of legitimate behaviour, including reporting by journalists, civil society organisations or human rights activists, as well as academics and other research activity. I am particularly troubled by the intention to attach serious criminal consequences, including imprisonment, to conduct that merely raises reasonable suspicion without requiring membership in or concrete support of a prescribed organisation is actually established, close quotes. 4. And finally, Professor Clive Walker says, often in quotes, it is difficult to know what is forbidden as associated with a prescribed group when the same symbol might have an historical and hallowed existence well beyond the usage by extremists. This point could apply to a flag with a black background with the Shahada written in white, as it does to the Irish tricolour. Let me now turn to the third proposed new or amended counter-terrorism offence. The government aims to update the Section 58 Terrorism Act 2000 offence, that of obtaining information likely to be useful to a terrorist, to cover terrorist material that is just viewed or streamed over the internet rather than downloaded in a permanent record. This proposal started life as a 3 clicks offence, but through amendments in Parliament, the proposed changes may mean that a person can commit an offence just by 1 click. It can also be called the Medusa offence. It means that a person commits an offence simply by viewing, that is, simply clicking into terrorist material, including viewing that material, for example, over the controller's shoulder. The offence can be triggered by clicking into a message sent on, say, a WhatsApp group. The reasonable excuse defence can be relied upon for legitimate academic research or not knowing that the material they click into was terrorist material in nature. There have been observations and criticisms of this proposal too. Let me mention 5. 1. Focus should be on the creators and publishers, the social media giants, to sanction them for allowing material to be on their platforms rather than on the passive consumers. 2 is that the offence may prevent freedom of expression to explore political viewpoints, an observation made by Professor Clive Walker. 3, but more significantly, is the comments by the independent reviewer of terrorism Max Hill QC when he advised, in quotes, "Thought without action must not be criminalised." While we can all agree that there should be nowhere for real terrorists to hide, we should also agree that legislating in the name of terrorism when the targeted activity is not actual terrorism would be quite wrong, close quotes. In other words, when a person clicks into accessing the terrorist material, the prosecution need not prove that the aim was to be involved in actual terrorism. 4, there is likely to be a chilling effect in that people may risk averse in accessing the internet for material for legitimate pursuits, and some may be extremely concerned about accessing material unknowingly. As Liberty explains, this offence, in quotes, risks criminalising academic inquiry, journalistic investigations, or passive curiosity without any intention to harm. While the defence of reasonable excuse may prevent the successful prosecution of some journalists and academics, the chilling effect of these provisions remains. It is a brave reporter or researcher who will be undeterred by the prospects of a 15-year prison sentence. 5, and finally, with the reasonable excuse defence, this reverses the burden of proof, placing the onus on the person to prove that they had reasonable excuse into clicking into the offending material. Something that might be hard for a person to raise and, more importantly, convince a jury in the present political charged climate. Let me now turn to the proposed new offence known as the designated area offence. Following a similar law in Australia, it would be a terrorist offence of entering or remaining in an area outside the UK that has been designated by the Secretary of State in order to protect the public from a risk of terrorism. The offence would carry a maximum of 10 years. This proposal, whilst featuring in the publicity of the CTBS Bill, was only introduced later. The government, in the designated area offence fact sheet, gives some reasoning for the proposed offence and how it will operate. It states, in quotes, "Foreign terrorist fighters present a significant threat to the UK and other countries. For example, since 2014 we have seen a large number of individuals travelling to Iraq and Syria to engage in terrorist-related activity." Close quotes. In his evidence to the Public Bill Committee, Assistant Commissioner Neil Basu, the National Lead for Counter-Terror Policing, was clear that a new offence of banning travel to designated conflict zones would help tackle the threat posed by foreign fighters. This offence won't apply retrospectively, and the offence will allow for a grace period of 1 month to allow a person to leave the area before the offence takes place. Once again, there is written into the proposal a reasonable excuse defence to allow persons with a valid reason to enter and remain in a designated area. What observations and criticisms have been made about the designated area offence? 6 are mentioned. 1. The first observation and concern is that the offence is akin to a trespasser's offence. That is, a person commits an offence simply by being present in an area without any need for the police or prosecution to prove actual terrorism. This offence is likely to affect so-called and unfortunate term jihadi brides, who arguably are in need of help rather than a term of imprisonment. 2. The territory of a particular prescribed group may be quite fluid, and so the designated area needs to be under constant review. 3. In future, there may be the temptation for a government of the day to designate areas less for security considerations, but for a desire to establish good diplomatic and trade relations, and use the designated area offence as a carrot for a good, not a no deal. One interesting question: will places like Gaza, Myanmar, Yemen, Kashmir, the Crimea be places on the designation list in future? We will have to wait and see. 4. In the case of what some call independence movements and liberation struggles from oppression, a selective use of designated areas may leave the UK at risk of being exposed to the criticism that it is taking sides in a conflict, leaving people defenceless, and where there is no identifiable risk of harm to the UK travelling to those in designated areas, that person would engage in acts of terrorism. 5. Many human rights workers, humanitarian aid workers, and even media monitors not formally associated with any particular organisation, and those visiting families in those designated conflict areas may find it difficult to show and, more importantly, prove the reasonable excuse defence to the requisite standard. And this reverse burden of proof on the person who would like to enter and remain in a designated area, even when they have good and noble reasons to travel there, such an offence may deter proper reporting, aid work, or visits to families. And 6. Rather than designated area offence, some argue that it would be simpler to criminalise any person to travel abroad in any conflict, to take up arms for any foreign government, despot or group, and send out a message that any lawful use of force can only be taken up formally by being in the UK armed forces. Liberty is reported to have called the proposals deeply concerning, and adding in quotes, "Keeping public safe from terrorism is an important and difficult task, but making travel a crime is the wrong approach. People visiting family members, helping others through humanitarian relief, or travelling for work could face up to 10 years in prison. Academic inquiry, investigative journalism, family relationships, and acts of solidarity will all suffer." Close quotes. And the advice is clear. If you are travelling to a designated area, entering and remaining in those areas, you will need to have prior good cause to travel to those areas and notify those in authority before travelling. Let me just summarise now other proposals in the CTBS Bill. Let me mention 4 briefly, but there are many more proposals, including, firstly, there is a proposal to confer extraterritorial jurisdiction on a number of offences, including glorifying terrorism, terror offence, to ensure individuals can be prosecuted for having encouraged terrorism whilst abroad. Citizens, political figures and campaigners seeking to show solidarity through marches or laying wreaths abroad in the presence of particular proscribed organisations like the PKK should take note, even if they are legitimate groups in the region. Secondly, the government intends to introduce a statutory bar on the admissibility of evidence in a criminal trial or oral admissions made in an examination at a port under Schedule 7 of the Terrorism Act. This has general support from all quarters. Thirdly, the government intends to introduce a stop, question, search and detain an individual at a port or border area in order to determine whether they are or have been involved in hostile activity. These are suspicionless stops of passengers, similar to Schedule 7 stops, where passengers can be detained for up to 6 hours, but with the added dimension that it is to determine whether they are hostile. It is likely to affect passengers from hostile states like Russia. And the same potential sentences apply for non-cooperation, 3 months imprisonment and a fine. Organisations like the Law Society have also been critical of the lack of access of a suspect's right to legal advice, especially during the first hour of detention. Fourthly, the government intends to allow local authorities as well as the police to refer individuals to the channel panels for de-radicalisation. Groups like Liberty have instead called for a review of the government's what they call flawed prevent strategy, as it, in quotes, broadly criticised for alienating communities it seeks to engage and damaging our efforts to combat terrorism. Let me now finally turn to the last part to provide some general advice to those who would like to comment on the CTBS Bill, whether they have concerns or would like to show support or even put forward their own recommendations to those in authority about how to keep this country safe whilst protecting liberty. Firstly, read and research the CTBS Bill for yourself. Secondly, contact local parliamentarians for their thoughts on the bill. Thirdly, share your concerns or show support about the CTBS Bill. Many have already shown support for particular clauses, whilst it is also true to say many prominent groups and individuals have expressed significant concerns over many of the clauses and made their own recommendations for changes. If the CTBS Bill becomes law, it is likely to lead to more, not less, investigations and prosecutions, where people from all parts of our society, including journalists, commentators, human rights and aid workers and others could face lengthy sentences. So, if it's about expressions of support offence, images offence, one-click offence, designated area offence, or the other offences and powers amended and extended by the CTBS Bill, please know your rights. Please know your responsibilities. Please know what you can say and do, and know what you cannot say or do. And where appropriate, know your reasonable excuse defences. And remember, speak to a specialist lawyer if you need to. Thank you for listening. Thank you for watching. Thank you in advance for sharing this video. And may the justice be with you.